Super. Chief Justice, thank you again for joining us at Anchored in Law. Judicial activism versus judicial restraint. What do you understand judicial activism to entail?
Well, I think it really depends on who you're talking to. Some people seem to think that judicial activism is about straining the law beyond the limits just to achieve whatever appears to be the right outcome for the case. And they perceive judicial restraint as not going all the way to do what in their thinking the dictates of justice require that you should do. I really don't believe in labels. I think here is the bottom line. Every South African court should see itself as being in the business of delivering substantive justice. Technicalities should never be allowed to stand in the way of delivering quality justice to our people. The notion that the law is an S has got no place in South Africa. Section 172 of the Constitution demands of us to make just and equitable orders. So whatever you have to do, just make sure that whether it's the Constitution or the law you are interpreting, at the end of the day, the order you make can truly be categorized as a just and equitable one.
Well, let's take an example of one judgment of this court. In, I think it's called the KZN Liaison Committee versus the KZN Education Department. You'll be aware in that judgment there was a split decision.
Sure.
Counsel for the applicant had been asked not once, not twice, but 3 times on whether he bases his case on public law or private law. On 3 occasions he says private law, contract. And yet the majority decision was founded on public law. There was a dissenting judgment by the DCJ and I think Jafta J and there may be others. Isn't that an example of a court determining what outcome it wants and then ignoring what counsel is arguing in order to get to that outcome? Isn't that an example of judicial activism?
You know, I was in the minority judgment. I wouldn't want to say anything about the judgment that I did not support.
I respect that.
Yeah.
Let's take a case in which you were not sitting. It is not a judgment of the Constitutional Court. It is in fact a judgment of the Supreme Court of Appeal. Where, now it escapes me.
Can I give you an example?
Yes, please do.
About 2-3 years ago, we had a matter of the IEC here. The IEC was under a statutory obligation to compile the national voters' roll in such a way that the physical addresses of people where possible, or a way of identifying where they reside is reflected.
Is that the Marathon judgment? No.
It was, what do they call Potchefstroom now? I'll remember. So the matter came before us. The IEC had clearly not complied with the statute.
Yes.
But a a slavish adherence to the statutory provisions would have resulted in a constitutional crisis. We were not going to hold the local government elections, and if a particular period passed without holding the local government elections, there would be no constitutional or legal avenue for ever holding them again. And you were going to have people either staying in office beyond what the law allows them to, or have no government at all. So we had to focus on Section 172. So, okay, just an equitable order. And in circumstances where a constitutional crisis has to be avoided, you cannot, in the name of administering justice, just robotically and literally interpret the law in such a way as to allow a crisis to eventuate. You can't. Whether you call it judicial activism or something else.
That's more purposive interpretation, I think.
Yeah, I saw it as, connecting with the fundamentals of our responsibility, and that is ensuring that at the end of the day, justice is done. And we delivered that judgment. We really had to think deeply about what is it that could preserve the integrity of our state. We found it, we applied it. We were divided, but that's the outcome that we reached.
Wasn't that the Merafong district municipality?
No, it wasn't Merafong. I'm trying.
Okay.
Tlokwe.
Yes.
Tlokwe.
And so I know you're running away from labels. You wouldn't, if you were pushed in a corner to label, you wouldn't label that judicial activism.
I'm incapable of being pushed in any corner.
Okay, but would that fit into the label? Not you now, but objectively. Would that judgment in Tlokwe fit into the label of judicial activism?
I suspect some people could say it is.
Yes, so that's a good enough answer. Last question on the judicial activism versus judicial restraint point. The full bench of the Pretoria High Court that ruled for the establishment of the State Capture Commission of Inquiry, among the orders there was that the president was not to appoint the chairperson of that Judicial Commission of Inquiry, but that the chairperson must be appointed by the Chief Justice. You and I know, I think, that the president is the one to whom the power to establish a commission of inquiry is conferred by the Constitution. It's 84, I think, something.
Yeah, it's Section 84.
Yes. And with that power comes the power to appoint the chairperson of the Commission of Inquiry. Now, the argument in the full bench was that the person who was to be the subject of that inquiry would be conflicted in appointing the chairperson of the very inquiry of which he was to be a subject. Now, let me phrase the question this way. Judges, as you know, Chief Justice, enjoy something called the presumption of judicial impartiality. They also have a constitutional security in that they are, in Section 165.4, I think, independent. Right? Here's the question. Is the reluctance of the full bench to allow the president, who is to be the focus, or at least one of the persons who are to be the focus of the Judicial Commission of Inquiry and the State Capture Commission of Inquiry, is the High Court's reluctance in allowing the president to appoint the chairperson not so much a reflection on the judicial independence and the presumption of judicial impartiality than on the president himself, on the person of the president? I'm not sure if that's clear because it's very long-winded. Let me try and simplify it for my own self to understand my own question. if a judge has a presumption of impartiality on his or her side and is also independent, as the Constitution says, a court that says a president may not appoint a judge to chair a commission of inquiry, isn't that court saying the judge who will be appointed by that president who is conflicted cannot be trusted to be independent, and therefore the presumption of judicial impartiality doesn't apply to him or her?
Well, I think by extension it could be understood to mean that. Remember, there is the case where the public protector had taken remedial action.
Yes.
To that effect, which the president then challenged before the High Court, and the High Court basically endorsed the decision of the public protector. Before we go any further, let me state my own position, because I'm somehow entangled in that process. I was asked by the media and other people several times before the matter was even resolved by the High Court, and even afterwards, why are you appointing the chairperson? I said, listen, the remedial action is not binding on me. No remedial action was taken against me. As far as I'm concerned, the power belongs to the president, against whom remedial action was taken. If he asks me, I will consider his request. And it was on that basis that I identified the chairperson. The president requested me. Knowing that the power belongs to him, I identified the judge and presented the judge to him.
But now that's an ex post facto act.
Sure. Now, as for the judges, you know, it is not unheard of that different judges in different courts can interpret the constitutional laws differently. I want to believe that my colleagues in that matter were interpreting the matter in line with how they were persuaded to see the issues. But here is the bottom line. Can you say that no human being, just because he or she is a judge, can ever be compromised?
Now that's a question I wanted to put to you, Chief Justice, and we will start with that question in the very next segment. Thank you.